Well, it is right at 9 o'clock. So I know that personnel administrators across the state are very busy and we want to honor your time. So we're going to go ahead and get started. My name is Dr. Heather Williams. I'm the Executive Director of Personnel Services for the Riverside County Office of Education. And it's my honor to serve as your ACSA HR Council President. One of the things that the HR Council wanted to do this year, in addition to our October Personnel Institute and the January Negotiators Symposium, was to bring you timely and pertinent training and information throughout the year. So we have coordinated this information session today regarding AB 438 with all the changes regarding classified layoffs that I know a lot of us are wondering how we're going to manage all of this. And so we wanted to bring this information to you this morning. So I'm going to let you know at the end of the meeting, we're also going to be asking you for ideas of other topics you'd like us to bring information to you about throughout the year. So start thinking about that, and you can put ideas in the chat if you'd like, but we'll take a few minutes at the end to ask you for ideas as well. With that, I would like to introduce you to our beloved Laura Preston, who was with ACSA, and now she has joined the F3 Law Group as the Director of Government Affairs, and she has helped coordinate this event this morning. So Laura, take it away.
Thank you, Heather, and good morning, everyone. Before I left ACSA all of a week ago, we had already started to prepare for this workshop, and as Heather said, the Human Resource Council has wanted to, and some of you may have hopped on calls last year during COVID, that we really want to be able to provide information to the field in a timely way and on topics that are of interest. So this format is different than our typical HR council. We have to, because it's so much larger, we focus on a specific topic and try to address those that are of interest at this time. And we know AB 438 is a hot topic and moving forward. Just a little context, the bill, just so you know, was sponsored by the California School Employees Association, CSEA, and is an attempt to provide equity between classified and certificated employees. Now, we all know the difference between all the laws between the two classes of employees, but the legislature just heard equity and was able to move through. Our response was much more convoluted, and we had to get into the kind of the nitty gritty of why it's not that simple. And that is not a good thing when you're trying to advocate against a bill, because the CSEA had the power of just a simple message, and legislators can respond to that. So there are a couple exemptions in the bill that I know Jordan will address. We really want to hear, and I'm going to be monitoring the chat box so we can feed questions to Jordan throughout that you have. And also we really want to respond to the issues that you have. So we didn't prepare anything official today. It was more of just a conversation with HR administrators throughout the state. And then we want to be responsive to really what you're looking for, other than, like Heather said, how are we going to deal with this bill next year? So we hope that we can focus some of what your needs are in the future as well. So with that, I'm going to be able to pass it off to my now new colleague, Jordan, who's a partner with F3. And Jordan is an expert in all of these employer-employee relations issues, which I call it rather labor and employment, I think. So Jordan, I'm passing it off to you.
Thank you, Laura, and thank you for having me here. I really liked doing these last year. I think this format is really cool. It just dawned on me that before COVID, I'd probably have to travel to do something like this. And I'm at home right now with one of my daughters who's actually quarantined. She's in another room, and yet I still get to do this, and so I think that's called progress. Okay, so for those of you who do not know me, and I see we have quite a few participants on this, so I'm assuming most of you do not. My name is Jordan Bilbeisi. I'm a partner at F3 Law. I am the chair of our labor and employment practice group. I work primarily with superintendents and human resources. I think you probably would recognize me as more like a general counsel than somebody who's actually going out and doing hearings. I'm helping districts prepare for negotiations. I said in negotiations, if you have an employment related issue, I can help you out with that. And then if you go to a hearing, I usually am going to delegate that out to a litigator, somebody who's actually going to do the hearings. And that includes layoffs, by the way. I've been doing this for a long time. And I could probably count the number of certificated layoff hearings I've done on one hand, yet I've helped many districts prepare for those over the years. So this is what we're going to talk about today is a bill that came out, 3 weeks ago? And it seems to have been in the works for like 3 years. I think hopefully we all knew this was coming. It wasn't too much of a surprise. I think Laura's right. It's an effort to achieve equity between classified and certificated employees. I think classified employee layoffs have for many years been a tool that CBOs have to make some budgetary cuts, right? For many years, it's been super easy to do. You just have to do it with a notice, and you say it's due to lack of work or lack of funds. Nobody could challenge you on that. And if you put yourselves in the shoes of CSEA and classified employees, and keep in mind post Janus, that Supreme Court decision from a couple of years ago, you got CSEA really trying to show that they are worth their dues. And so they are saying, wait a minute, how come we are an easy budgetary tool for you to use? You could lay off our employees, really eliminate them from employment, but you really don't do the same for your certificated employees. What's the difference? Why are we less worthy? So, if you put yourself in their shoes like that, you can understand why the legislature passed this and the governor signed it. But that said, those of us in the business know this is a bit of a nightmare. And so I don't think it's that confusing, right? I think I'm going to assume that all of you have at least familiarized yourselves with the bill a little bit. I don't want to spend too much time going over like all the details of the bill. What I want to do instead is I'll just very quickly give you some context of what the bill says, and then try to give you my perspective on what it means to me. The kinds of things that I'm advising clients about and I'm talking to them about. And by the way, this came out 3 weeks ago. Nobody has done this yet. This is similar to certificated layoffs, but it is not the same. So anyone who tells you, hey, we know everything about this bill, you show up and we'll tell you everything you need to know. That is probably not the truth. I don't think we're going to know what this actually means until the summer. Right, until after we start, if there are layoffs this year and we start getting decisions, we'll start figuring this out. And as we start preparing for it and we see where the mistakes are, then we'll know. Right now, we're taking guesses, educated guesses on what we need to do to prepare for this. And so I'm going to talk for a little bit. I know we have an hour. I don't want to talk for the whole hour, but I think it would be best if I just kind of give my overview and then you can ask questions. And I don't know if Heather or Laura, if you could monitor the chat, if anyone wants to put questions in there. I think I've learned over the past year and a half that if I'm speaking and I'm watching the chat, that it gets a little messy. So if you could direct my attention to any questions out there, I'm happy to answer them. And I should put out there, I may not know the answers to all your questions today. I will give you my best shot, but again, I don't think we should pretend that we have all the answers here. Okay, so what is the bill? Just real quick, give you some context. I'm sure you're familiar with it. I'm just going to give you the way that I see it. In past years, to lay off classified employees, you just had to get a board resolution. You could do it at any time of the year. You just had to give the employees then 60 days notice. After the board resolution is going to say it's due to lack of work or lack of funds. There is another reason to lay off classified employees if there's an expiration of a specially funded program. I'll mention that later. I actually can't remember a single time I've ever used that in 15 years. So I don't know that I want to spend a tremendous amount of time now deciding that this is something that we should be using. It's always been for lack of work or lack of funds, because again, you could say that and no one's going to challenge you on it. You just pass the resolution. You send the notice to the employees who are affected. It's got to be 60 days in advance. I think it used to be 30 days. It changed to 60 days a few years ago. And you're going to have to determine then, is there bumping? Okay, and bumping means, you're in your collective bargaining agreement, or if you're a merit district, your personnel commission rules. They're going to say, okay, well, if you're subject to layoff, but you have experience in another lower classification, you can bump that person or displace that person out of their position and you take it. It's like musical chairs, right? And so what you do is you give the 60-day notice to the person who's going to be laid off, and you give them the option that they're going to get bumped. And if you want to bump, you could take the position. If they say yes, you then gave another 60-day notice to the person who's going to get bumped. And it goes on and on and on until finally, musical chair, somebody is without a chair. Somebody's actually going to be eliminated. They're going to be put on a 39-month reemployment list. Bumping doesn't always happen, right? Some districts don't even have bumping rights. It's not required by law. It's by collective bargaining agreement or personnel commission rules. But I mentioned that, and I'll explain why a little bit later, because the process I just mentioned is a multi-step one, where you can do 60-day notice one day, 2 weeks later, another 60-day notice, 2 weeks later, another 60-day notice, right? And so it's a continually shifting timeline that is entirely up to you and your board. So it gave you quite a bit of flexibility in terms of when you could lay off employees. Okay, so now, as if March 15th wasn't scary enough for you already, you now have another deadline to worry about on that day. Just like certificated layoffs, if you are going to lay off a classified employee for lack of work or lack of funds, you cannot just give notice at any time of the year. You cannot eliminate them at any time of the year. You can only eliminate their position to go into effect the following school year. All right, so if you want to lay off a classified employee beginning January 1, it's not going to go into effect in March. It's going to go into effect July 1. You have to give a notice to the employee now on or before March 15th. All right, and you're familiar with March 15th, so that's not going to be a shocking date, or, I know board meetings tend to get a little hairy before then, so this will be another thing for you to think about. The notice is going to be a little different. Before, you're telling the employee when you give them the layoff notice, you are being laid off, right? Now you're telling them, this is our recommendation that we are laying you off. Again, this is very similar to the certificated process. We're recommending that you get laid off. Why is it a recommendation? Because they can challenge it now. Okay, so that's the second big difference. They could not challenge this before, which is great. We always talk like if an employer, a public agency that has a limited amount of funds that it can use, has a situation where it no longer has the work for this person, or it no longer has the funds to pay for this position, it seems that should be within its tools to eliminate the position, right? To maintain a healthy budget. And if you allow the person to challenge that, that can undermine that ability, right? And so it is what it is. Certificated employees can challenge it. Classified employees can challenge it now too. Within 7 days of getting that March 15th notice, they can file an appeal. And I don't know how many of you are familiar with the certificated process, but they're going to appeal. Everyone's going to appeal. I've just put it in the bag. Once the appeal, and this is where I don't want to get too into the weeds of like the kinds of stuff that lawyers should be aware of, because I don't know how many of you have ever done a certificated layoff hearing yourselves and presented the case to the administrative law judge and all that. I don't know of any district administrators that have ever done that. It's always done through legal counsel. But if a hearing is requested, it's going to go through the same administrative procedures as a certificated layoff at that point. An administrative law judge through OAH is going to be assigned. There's going to be a hearing date set. There's going to be exchange of evidence. It is a very involved process. It is definitely the kind of thing that I recommend you use legal counsel for. It's probably what I would consider to be a good use of legal resources, because it is so complicated. CTA always uses lawyers. I don't think CSEA is going to use lawyers. I've spoken to some of their reps, and they think that the senior LRRs will be handling these, which could be interesting. So just really quickly, the ALJ gets assigned. The ALJ is going to determine whether or not an ALJ is an administrative law judge, whether cause exists for the layoff. So what is cause? That is a question that we do not have the answer to right now. Cause is, I think, whether or not there are lack of work or lack of funds. There is sufficient evidence to sustain that there's lack of work or lack of funds. We also know that the bill specifically states that cause includes whether you got your seniority list right. In other words, that you went in the correct order. And so that's an important takeaway of this. If your seniority lists are not up to date right now, it's time to get them up to date. right? And classified employees, remember, you are looking at hierarchies of positions. You're looking at classes of positions, right? Because the classified layoff is what? The order of layoff. You've known this for years. It has not changed. The order of layoff is within the classification. And that's I think that's an important distinction that I'm going to mention right now. When you lay off a certificated employee, the main reason we lay them off is because you're eliminating a particular kind of service, right? And that's when you're looking at credentials and a whole bunch of stuff. Classified employees is different. You're looking at a specific class and you're saying due to lack of work or lack of funds, we need less of these employees or these positions. And so the layoff is going to be within that class. And then of course there could be bumping into lower classifications. But again, that's getting a little bit too much into the weeds. So does this mean you cannot do a layoff? Or that the ALJ is going to tell you, you know what? You haven't proved that there is sufficient evidence that you have a lack of work or lack of funds justifying the elimination of this position? The answer to that is no. The ALJ has authority only to give you a recommended decision. That is not binding on your board. By May 15th, you're going to get that decision and the board's going to have to take action. So there's going to be two steps here for the board. One is authorizing the March 15th notice. The second one is going to be finalizing the layoff. And the board can reject the administrative law judge's decision. So I think that's very important to know. Of course, I'm saying that, hey, listen, this is what the law says. Could be different in reality, politically, if you have an administrative law judge saying there is not enough evidence to support your administration's recommendation to lay off these classified employees, and then you have these classified employees showing up at a board meeting, essentially telling the board, please don't eliminate our jobs, right? That could be a difficult spot for your board to be in. But that said, the board makes the ultimate call here. And so why then, if you can still lay off employees, why is this bill in place? And the answer to that is simple. This is my major takeaway of this. It's not to prevent you from doing layoffs. It's to discourage you from doing layoffs. Because if you look back, how many certificated layoffs do you think you've done since 2014? I could actually, personally, the number that I've done, I could count them on one hand. Very few. And what districts are districts not trying to eliminate certificated positions? No, they are. They are pretty much every year. They're thinking about how to do that. But how do they do that? Through any other way other than a layoff. Whether attrition is one way, retirement incentives, right? You're trying to encourage people to leave without having to go through this process. And why? Because the process is a nightmare. It's costly. It's time consuming. It's difficult. Again, we don't know exactly how this is going to work for classified employees, but just looking at it and thinking about it, I don't think it's going to be any easier. Some people think it's going to be harder. I don't want to go that far, but I don't think it's going to be any easier. So this is intended to discourage you from laying off. It's also intended to limit the time during which you can lay off, right? So when you hire a classified employee, you have that person essentially for the year now. You can't just get rid of them a month, a couple of months from now. You have them for the year.
Jordan,
so
there's a couple of questions. Would you like me to interrupt you and offer them now, or would you like them at the end?
No, go ahead.
Okay, for one of the questions is, for some county offices, superintendents are elected and considered the employer. Would he or she be able to make the final decision, or does it still have to go to the county board for termination?
You know what, Laura, I'm sorry, I don't know the answer to that question. The statute is specific as to the authority of governing boards to make the ultimate decision here. So, if that is ultimately the person who is the superintendent is elected and considered that authority, then I suppose that would be it. It's whoever gets to pass the resolution to authorize the action, and then ultimately gets to take the final action, and it's usually going to be through a majority vote and a resolution. That is essentially, we're really just talking about the final authority, right?
Yeah. And then these are kind of a couple, I don't know that we know the answers yet, on should there be tiebreaker points for classified employees when you get to, when you're bumping. And I don't know that we know that yet.
Well, I can answer that question.
Okay.
which is, it's up to you. For certificated layoffs, you actually, the certificated employees have a statutory right to displace other employees, right? These statutory procedures for certificated layoffs specifically state that, boards have to adopt criteria for tie breaking and for skipping, right? So that's another step you got to do. That is not present in this bill for classified employees. And I think maybe this is a good time for me to go to what has not changed, right? In other words, what has this bill not changed? And it's pretty much everything else other than what I just mentioned. So the order of layoff, that it has to be in the order of seniority within a classification, that is the same. Reemployment rights, which include that you are reemployed in the reverse order of seniority in your class if there's a vacancy, and your Tucker rights. You know what the Tucker rights are, right? You have preference to a vacant position in a different classification over an outside candidate, so long as you are qualified. Those are exactly the same as they were before. Another thing that's the exact same is that bumping rights or displacement rights, if they exist, they only exist because you bargained them or because your personnel commission, if you're a merit district, has adopted rules that provide for bumping. If you are a district that does not have classified bumping rights right now, my opinion is that you should not now add them to your collective bargaining agreement. I don't think now is the time to do that, because I think that bumping is going to be way harder now because of this. And Laura, if you don't mind, let me explain why. And I just answered real quick your question. If you're going to have tie breaking, it's going to be a product of collective bargaining. Or if you're a personnel commission or merit district, your personnel commission could adopt rules about tie breaking. So I'm not going to say they don't exist, but if they do, it's because of you. They exist because that's what your district wants to do. Bumping has always been, like I mentioned before, if it exists, it pretty much says you get a layoff notice. And in that layoff notice, it's going to say whether or not you have a right to displace or bump someone else out of their position. And it gives you a period of time during which you can elect to take that. If you don't take it, you go to the reemployment list. If you do take it, you then issue a new layoff notice to the person who's getting bumped, and it goes on and on and on. You cannot do that now because you have one date to get this done by, and it's by March 15th. So imagine this, you get the board resolution before March 15th, you know how these go, right? It's usually the board meeting right before March 15th. You issue the layoff notices, you give someone an opportunity to bump, and they let you know after March 15th, right? Or you don't have another board meeting, or it's going to be hard to get another board meeting. That's going to be very difficult for you to do. So you could either get going on this very early, in which case it may be difficult to prove lack of work or lack of funds by the time you get the hearing going, or you do what we do for certificated staff. You overnotice, right? And I know that's a little harsh to give out a lot of pink slips, but I think what we've landed on is the best approach would be you look at the positions that are for sure. Here's how many positions we for sure need to eliminate. Here are the least senior people in classification. Okay, these people are going to get notices. Here are the positions and the people that these people could potentially bump if they elect to take the position. Let's give all those people who are going to get bumped notices too. And then who are any people that those people could bump? And hopefully it doesn't go down too many more tiers than that. I would give notice to them too. So in other words, you're going to be giving potentially a lot more notices than the board is going to eventually approve in its final layoff authorization. You're going to end up rescinding a lot of layoff notices, which is what we've always done for certificated staff, and which CTA is very familiar with, right? They tell a lot of their members, don't worry, we think you're not going to end up getting laid off. But over noticing, at least right now, I can change I may end up changing this opinion as we get closer, but for right now, I think we have landed on over noticing as a prudent approach to making sure that no one is left behind. Or if you don't have bumping rights, just don't add them to your collective bargaining agreement now.
Good advice, I think, right? Hey, Jordan, another question that came in is with regards to retirement incentives. Can retirement incentives for classified be prior to the end of the school year like they are now? Does this law change anything there?
There's nothing that I'm aware of that's going to prohibit that. Well, largely, retirement incentives are largely a product of what your board authorizes, what makes sense from a budgetary standpoint, right? If you're going to pay people to retire, does it make sense for them to take the money to leave? Is this something that you were actually incentivizing them to retire, or are you just incentivizing them to give an early notification of retirement, right? The amounts you pay could be considerably different depending on those two things. Retirement incentives, I know that there's some difference of opinion on this, but it affects employee wages. It's negotiable. I know a lot of unions do not want to negotiate it. They don't care to negotiate it, but it affects employee wages. It is negotiable. So, it can also depend on what CSEA or if you have a different classified union, what they're willing to agree to. But my experience is that retirement incentives just before the end of the year are pretty uncommon, because if somebody's planning to retire, they already know that by then, and they probably have already given some indication or notification by then, in which case giving away money may not be the best idea, right? It's usually you want to start thinking about these things relatively soon, offering them soon, so that you really are incentivizing people to do something they may not otherwise want to do, right? Maybe this is the year for me to retire because I can take a pretty good payday if I do that.
There's a couple questions, but I want to let you continue to go on because you might be addressing them. One is about the probationary exemption and also about reduction in hours and how does that impact versus reduction in force. Okay,
and I saw those, and those are really good questions, and those are points that I was going to talk about. Let's talk about probationary employees first. So unfortunately, unlike certificated employees, there's layoff procedure for probationary and permanent employees, right? This procedure for classified employees only applies to permanent classified employees. However, the law states, in sort of ambiguous terms, but I think it's clear enough for me to understand, that if you are probationary on March 15th, but after that point, before the end of the school year, you will become permanent, that you are entitled to the same layoff notice as a permanent employee. Essentially, you have to treat them as permanent. Combine that with the fact that a couple of years ago, the legislature made the rules uniform between merit and non-merit districts, that classified employees now have 6-month probationary periods. That could mean you have quite a few probationary employees who fall within that category. So, you have the combination now, I think very much intentional on CSEA's part, of a short probationary period and this layoff process that begins well before the end of the school year that may include them. I recommend, and I am recommending, because I know school districts, a lot that I work with, so I'll just won't name any names here, but over the years, it's been pretty consistent. Their processes for releasing classified probationary employees are pretty inconsistent. It largely is up to mid-level directors or site administrators to make the call on whether or not they're going to release them. There could be multi-step evaluation requirements in a collective bargaining agreement that apply after, every 2 months during your probe period that are not met. And I can't tell you the number of times that somebody has given me a call asking if they could release someone, and we do the math, and it's been like 1 week after the probe period has ended, and nope, they're permanent. So if you haven't already, you should really tighten up your process for releasing probationary employees. Remember, you can release a classified probationary employee for any reason, right? A lawful reason. It can't be like discrimination or discriminatory or retaliatory or anything like that. Before the 6-month period. Your collective bargaining agreement, your personnel commission rules may provide something more than this, and I recommend that you check that out. But generally speaking, you have as broad a rights as you could possibly have when it comes to releasing classified probationary employees. You can still do that. However, there is a court case dealing with certificated layoffs that hold that a school district cannot release a certificated probationary employee if it's due to the same reasons that fall under the layoff process. And in that case, remember, it's a little bit different for certificated employees than it is for classified employees, but I think it's fair to assume that a similar reasoning could apply to this, that if a classified employee in probe status is released and they're being released because you just don't have enough work for them or you don't have the funding to continue their position, I think you could be susceptible to a challenge that what you actually should have done is follow this new statutory layoff process. So I would, again, be very careful about, well, if you have this rule of thumb, we usually don't explain why a classified employee is being released. Your collective bargaining agreement and personnel commission rules may require something different, but usually there's no explanation. It's, thank you for your service, we're releasing you. I don't recommend that you go much further than that unless you have to. And you probably want to consult with legal counsel now, just to make sure that each of your releases is okay in light of this new law. But I guess that would be kind of a big takeaway for me, something that you all should be thinking about in preparing for this and getting used to this new law is, if you're not releasing classified probes now, you should probably start doing that. Laura, reductions, you mentioned reductions in hours. That was the second one. This has been a debatable topic between attorneys and unions over the past couple of weeks. Specifically, some have asked, well, wait a minute, do we need to even reductions in hours? Let me back up a second. Reductions in hours are subject to bargaining. Okay. A reductions in hours is actually different from a layoff in that context, because for a reductions in hours, PERB has held that you have to bargain the decision and the impacts and effects. A layoff, on the other hand, you only have to bargain the impacts and effects of your decision, which is not negotiable. It's a key distinction. However, I know from practice that most districts treat a reductions in hours just like it's a layoff. They give the 60 days notice. They give them reemployment rights. It's probably in their collective bargaining agreement that defines a layoff as including a reductions in hours. I know not everyone does this, but it's very common. And so when this bill came out, I think a lot of us thought, whoa, does that mean reductions are no longer negotiable? I think the answer to that was pretty clearly, no, they're still negotiable. But are reductions in hours even subject to this new procedure? And I've landed, and so have many of my colleagues, and I talked to a senior CSEA labor relations representative the other day, and he says CSEA also agrees that reductions in hours are not subject to this layoff procedure. The only time a reduction in hours is going to be subject to the statutory procedure is when the employee has voluntarily consented to a reduction instead of being laid off. And so in that case, you're basically talking about like a bumping scenario, right? Where the employee gets a layoff notice. Hey, you're going to be eliminated, but in lieu of being laid off, you could alternatively take this position with fewer hours. In that case, it's a layoff. The education code section, is it 45101G, defines that as a layoff. There's case law that says that's a layoff, and that's where reemployment rights are triggered. But any other reductions in hours, and I think this is the majority of the reductions in hours that districts do, when an employee does not consent to the reduction, and it's not in lieu of being laid off. You're not saying you're going to be eliminated or else you could take a reduction. You're just saying we're reducing you from 1.0 FTE to 0.6 FTE. That is not subject to this layoff procedure. So you can do that any time of the year. You don't have to give 60 days notice, although your collective bargaining agreement may require you to do that. But you have to bargain the decision and the impacts and effects. So that means giving your classified union notice before you make the decision and an opportunity to bargain, which means what? They can hold it up, or they can ask for a pretty big ransom for the reduction. I cannot think of a single time that CSEA has ever taken a reduction in hours decision to impasse. So the reality is they're probably not going to stop you from reducing hours. They may ask for something in exchange, but they're probably not going to stop you from doing that. So that would be lesson number 2 here for me, is if the layoff is going to be too hard, is a reductions in hours an acceptable alternative? And I think this transitions into another thing I wanted to talk about. And Laura, you're free to interrupt me if there are any questions on these topics, but bargaining. Okay, you all probably, I think, have collective bargaining agreements that have layoff articles in them. Certain parts of those are no longer going to be enforceable. Specifically, the part that says that you give 60 days notice to someone who gets laid off and there's no hearing right. The law is going to supersede those. But you're probably going to want to bargain them to update them. And I think you have a decision to make when you get in there. If you have been like one of the districts I work with who have been treating reductions in hours like a layoff, and it's probably because of their collective bargaining agreements, now would be the time to figure that out in your collective bargaining agreement, to essentially separate the two things. Because if you can have a process in your collective bargaining agreement that says, here's how we do reductions in hours, that could pave the way for you to not have to bargain these every time. And one thought that I've been thinking about and talking to CSEA reps about in negotiations is, well, what if we just continued giving them 60 days notice and reemployment rights? We've been doing that for years. Nobody cares. It's easy. And I think there is some interest in that from CSEA. It's just an option. You don't have to do that, but it is an option to think about a way. But if you do that, I would want CSEA to specifically say that this completes all negotiations regarding any decision and impacts and effects to layoff employees. In other words, this is comprehensive. We do not have to bargain this every time we do this. And I think that's a little bit of a mountain to climb, but my thinking is now would be the time to do it. I don't know that you're going to have the leverage to do this a couple of years from now. I don't think anyone's going to have the appetite to go back into your layoff article after you make the changes this year. So that's what I'm going to try to do in negotiations. But it's definitely something for you to think about. If you've been doing it differently before, if you've been processing reductions in hours as layoffs, I don't think there's anything to be ashamed of. You're probably in the majority of districts in doing that. Laura, do you have any questions that I see the chat moving, but I can't keep up.
I did. And I, for some reason, can't respond to a couple of them. One of them I was trying to answer, but I'll let you do it, is there's a question about the bill includes the 2%, the lack of funds, and that the total LCFF formula apportionment of ADA does not increase by more than 2%. And I'm sure that's the August layoff date notice, but I want you, can you clarify that a little bit more?
Yeah, so I think that transitions into a topic that I wanted to mention probably towards the end of this, and we're getting there, is, what are some ways to avoid this lack of work, lack of funds, layoff process? And there are actually 2 other kinds of classified layoffs that I should mention. One of those is Laura, what you just mentioned. It's called the summer layoff. That's what you're familiar with, that certificated employees can do. I can't remember the last time that happened. It almost happened last summer, but then the legislature said, no, you can't do that. So that is going to be a very rare circumstance. I really would not hang your hat on, we're going to do a summer layoff. Summer layoff is you have experienced a significant decline in enrollment, which I think a lot of you probably are nodding your heads and saying, yep, that's what we're experiencing right now. And Laura, I don't have the statutory language in front of me right now, but the level of funding you receive doesn't meet the 2% threshold. If that's going to happen, you're going to start getting notifications from your county offices, probably from school services. They're going to let you know that this thing is in play. If that happens, the procedures that I just talked about do not apply. They're largely going to be up to your board on how those layoffs apply. They're going to have to happen pretty fast. But again, that's something I don't want to spend a tremendous amount of time for this conference for, because that's hanging your hat on a very rare animal. Maybe a little more common now is for specially funded programs. That actually has been in the Ed Code for a long time. It said that if you are laying someone off because they are classified employees employed with basically special funds, right? right? And that funding is going to expire. You have to give them 60 days notice, right? You can't just lay them off on the spot. You have to give them 60 days notice. Well, the bill has a provision that states that, and I'm going to pull it up here. It says, notwithstanding the other requirements of AB 438, other requirements, you can give 60 days notice to any classified employee who's being laid off because of the elimination of special funds, right? A specially funded program. And that's another head scratcher because, well, what do you mean the other requirements? Do you mean 60 days notice, but they have the right to challenge it and get a hearing? We think, or at least I think, I know that not everyone thinks this, but I think that means that the requirements I talked about, March 15th notice, right to a hearing before an ALJ, those do not apply. Those are other requirements of the bill. I do not think that those apply to someone who is hired and laid off because of the expiration of specially funded special program funds. Again, that is something that we could get clarification from in a new bill. I don't know. I doubt that that's what CSEA intended. My understanding is that was a compromise in leading up to this legislation. And if you think about it this way, when you have certificated employees hired with special funds, you hire them as temps, right? You hire them under section 44909. It's either a temp or a probe zero. Probe zero meaning they don't acquire permanency in that position. And there's a reason for that. It's because the legislature wanted you to have the ability to release that person when you no longer have the funds to pay them. And I think this is very similar to that. And so if you are going to hire someone with special program funds, a classified employee, here would be another takeaway of mine and some advice for you. I think you have to tighten up your hiring documentation to verify that that is the case. So if you have an offer of employment you use right now for classified employees, and I bet it's pretty light, whatever it is, right? I don't really work on too many of those, but I think you should really start thinking about, and let's use an example here. I'm not saying this is a certainty, but you have to hire paraprofessionals with AB 86 funds, right? Those are special program funds. Should you have designated anyone you hire from the outside that they're being hired with those funds? If you do that, once the funding expires, arguably, just give them 60 days notice. The funding is expired. You have a lack of funds. Not very difficult to eliminate that person at that point. And it makes sense because you no longer have the funding to support them. I think that is an approach you should think about. Again, I think there is some ambiguity in this. Some others have kind of come the other way on this and thinking that, well, no, other requirements just means you don't have to do it by March 15th, but you still have to give them a right to a hearing. I don't see that in the bill, but if that is the requirement, I would expect the legislature or someone in authoritative position to let us know before March 15th. That is my next point here, and the transition is I mentioned temporary employees in the certificated world. Well, you have that in the classified world too. You've always had that. They're called short-term employees or limited employees. For non-merit districts, they're defined in, I think, Ed Code section 45103. 45103 or 45102. It is very specific of how you can hire someone like this. The board has to essentially take action certifying that you do not have, here's the service we need you for, here's the duration of it. It will not exceed 75% of a school year. And we will not have a continuing need for this service. I think school districts should seriously consider hiring more short-term employees. And CSEA will probably put up a real fight about this all of a sudden. But I have long understood this statute to give districts pretty broad rights as long as they can meet those requirements I just discussed. Because again, you're talking about a short-term need. Why should a school district take on a continuing financial obligation if it has a short-term need? I wouldn't use this so expansively that essentially you can't demonstrate that there's no continuing need. Like for example, if you continually hire short-term employees to do this, to fill the same services year after year after year, well, then there is a continuing need for this, and that would not be an appropriate use of short-term employees. But, I just mentioned hiring people with, special funds. Well, I think in the past, someone like that would probably be hired as a short-term employee. I think a lot of districts hired paraprofessionals with AB 86 funds as short-term employees, and they'll be able to release them before 75% of the school year without having to go through the layoff process. And this bill makes clear the layoff process does not apply to short-term employees. So that's another thought, and if we're tallying up my thoughts here, I think we're talking about tighten up your probationary release procedures, tighten up your hiring documents, right? Make sure that if you're hiring them with special funds, you document that. Think about, is this someone who could be hired as a short-term employee? And then I think just more broadly, I just think you got to be more careful in hiring. And right now, I know that districts want to hire. You're having trouble with staffing and you want to hire. And I was at a district last week and they were talking about how desperate they were to hire more instructional aides, and they were ready to offer them anything to get them in. And I just had the discussion with them. I said, I know you need this, but I think you need to assume that when you hire someone now, a classified employee, you hire them like you hire a certificated employee, such that when you bring them in, you have to assume you own them. They have a property right to their employment, and it's going to take moving a mountain to get rid of them. So I think it all starts at step one, making sure that you're making a smart decision in hiring the person, and that you are hiring them under the appropriate criteria. And always assuming, and your CBO should take the standpoint too, that this is a financial obligation that we are assuming on an ongoing basis. Because like I said at the beginning, just because you can lay off classified employees does not mean that you will want to, or that your board will want to take on the heat for doing this. So I think that would be, I think, my last major takeaway from this. If you have any other questions, let me know. I think the only other point I wanted to make before I'll stop talking, Laura, and just answer a couple questions before we're done is, don't forget that you are still required to bargain impacts and effects of a layoff. This does not change that. You have layoff articles. I think you all are going to need to, those of you with unions are going to need to negotiate some of this. So that would be another takeaway of things that do not change. Negotiating impacts and effects of a layoff are still there, but CSEA and a district, or CSEA, any classified employee union, you cannot negotiate the March 15th and May 15th dates. You cannot negotiate that away. There's case law for certificated layoff says that is not negotiable. So that's really the only element of a layoff that's no longer negotiable. Every other impact and effect is.
One question I want to ask to you, Jordan, that's come up a couple times in the chat is, what is the impact on this on non-unionized employees?
Oh, well, this bill does not discriminate between being union represented and non-union represented. It applies to classified employees of all stripes, rank and file, confidential, management, right? Anyone who's classified employees are treated equally under this law. The only difference would be the one I just mentioned, which would be you don't have to negotiate. And if your board policy or your personnel commission rules have bumping requirements for classified management, supervisory, or confidential, maybe you want to reconsider those. Maybe you want to look at them and remember, you don't have to negotiate those when you don't have a classified employee union. Now might be the time to do something about it, because I think that is going to be the biggest headache of this.
I want to encourage anybody to ask questions in the chat, because after this is over, we're going to review them and make sure that we are able to answer questions that we may, want to go into a little bit more detail. One of the, I guess some of it is going to be what I'm gathering from a lot of the chat is really about how districts are going to when they hire somebody, how they're going to let them know what they're hired as. Are they considered a temp? Are they considered that they're hired under special funds? Are they, and that kind of, I think is going to it may just take some time to negotiate that out over time, not negotiate like collective bargaining negotiate, but, navigating probably is a better word. Is there any kind of guidance that you, that you would give that when you're hiring somebody on using those special funds, that you just let them know up front that you're hired as tied to these special funds and your job is you're going to receive a 60-day notice, or how does that work?
I mean, the way I envision that working is very similar to how you hire a temporary certificate employee. You should have a specific offer of employment that identifies, you're being hired under special program funds, or it has a box on it and says hire, special program funds or other or something like that, and you check it. It would not be that difficult for lawyers to be able to come up with something like that. If you have an offer of employment now, you just send it to them. They could probably tighten it up and update it. Again, I'm not advocating for like expansively using this to the point to where it kind of undermines the, I think, very limited nature of it. But if you are hiring classified employees with special program funds, then I think you should be able to take advantage of these exceptions.
There was a question to repeat. What's the board's action on March 15th and May 15th?
Okay, so this again is something that we are predicting, and we'll be coming up with recommendations as it happens. And so I don't want to get too far in front of myself, but like a certificated layoff, certificated layoffs actually have quite a few steps before March 15th because you have to adopt tie-breaking criteria and other steps. You don't have to do that here. You're just going to think about what you do now before, before you send out the layoff notices, you have the board pass a resolution, right? That is going to certify that due to lack of work or lack of funds, we have to eliminate so many positions. They're going to be identified in an exhibit. That's what you're going to do before March 15th, but you are now going to frame this as a recommendation, or it's a proposed, you're proposing to eliminate these positions, right? And that authorization or that resolution is authorizing the district superintendent to provide those March 15th notifications. So that's board action number 1. Board action number 2 is going to be this: between May 7th and May 15th, I'm sorry, you're going to get the ALJ's decision by May 7th. So then you're going to have to take action by May 15th. And that action is going to be to finalize the layoff. And so that resolution is actually going to look a little bit, I think, like the ones you do now. It's going to state firmly, right? It's not proposed. This is the action we are taking to eliminate these positions. And then the employees will get final notifications of what is happening. So 2 steps. It is not, I don't see that as confusing or as time consuming as a certificated process. But I think generally speaking, to make sure that your boards are prepared and that you are prepared, you probably want to start thinking about this in January and February, just like you do with certificated, right? February would actually be pretty late for me. I know most districts start thinking about this around December, actually start formalizing documents around January, and then their boards are thinking about taking action around February. You need to have your seniority list. You need to have your seniority list done. Like if those things are not up to date, it's time to update them and continually update them. So this is not a nightmare come wintertime.
Are there any exemptions for tiny school districts with under 25 total employees?
I am not aware of that. No. The exemption would probably be the practical reality that it's going to be a very limited layoff if that's what you have to do. And some of the hiring considerations that I mentioned are going to be maybe a little easier when, you can really put some thought into, do we need this one person or not? Because, I work with a lot of very small 1 school districts, and I know hiring one person could have a significant impact on their budget, and they'll think about that very hard. And I think a lot of those do kind of take advantage of hiring short-term staff more than others. And also their probationary practices there, they're maybe a little bit more on top of it because the person's right in front of you all the time.
There's one last question that I want to mention. I got to go up here. It's the question was actually from Heather, and it's we provide certificated employees with verification letters in the fall where they confirm their seniority date, position, and credentials held. Should we do something similar for classified? And if so, how would we do it, as they may have held other previous positions? Do we do only the position they are currently in, or is this process not needed for classified?
Yeah, I don't know that that makes sense for classified. I mean, maybe, I mean, I guess if you're not aware of it, if you're missing some information and you think that your employees could help you fill in the blanks, go ahead and do it. But, you know, seniority for classified purposes, it should be something that HR is a bit more on top of. You know, remember you have it's seniority within classifications, right? And so you're talking about how many maintenance worker twos do we have? You know, what's and who's the most senior? How many maintenance worker ones do we have? And who's the most senior? You're looking at hire dates, you know, and if there is any confusion, you know, working with CSEA on that, I don't think would be a terrible thing to do at this point. And it's also worth remembering that CSEA and other unions too, they have a right to request information from you. And it's not just request information, but it's a continual disclosure of names. And remember, this happened after Janus. It's a way to so that they can be aware of essentially new employees coming in and do the orientations with them. But that also includes, I know a lot of districts they continually provide CSEA with their seniority lists. I could easily see that being something that CSEA is going to want to do going forward, and to make your lives and sleep at night a little better. I would try to get those going, you know, right about now. Just really start trying to figure those out and what they look like. Classified seniority lists are relevant in not just this context; they're relevant in all kinds of contexts. So, you know, if you haven't done it, I would definitely do that. But asking employees to verify, I don't think that's something, you know, you couldn't do if you are missing some information. It just seems, just off the top of my head, something maybe a little bit more unusual for classified than certificated.
We have one last question, and then I'm going to pass this back over to Heather. What's the distinction between seniority within classifications versus hire date?
Okay, that's probably a question that's beyond the scope of what I came in here to discuss. But your seniority within a classification typically means when you were put into that assignment. Okay. And what you have to look at when it comes to seniority is, how is seniority defined in your collective bargaining agreement? How is it defined in your personnel commission rules? How do you define length of service there? And there are different definitions in districts, right? There are certain limitations that the law provides, but I do think that answer to that question is going to be how it's defined in your collective bargaining agreement, personnel commission rules, or board policies, whichever applies. So I know that's not a very direct answer to your question, but the answer to that is in your district.
Jordan, thank you so much. You've been awesome and provided so much information to the field. Thank you. Heather, I'm going to pass this over to you for your last comments.
Okay, thank you, Laura. Again, I just want to reiterate, Jordan, thank you so much for being with us today. At one point, we had like 150 people on this call. So that shows you how we're all just dying for information on this topic. So we're grateful for you, and we're grateful that you've kind of stood by us through the last year and a half at these ACSA phone calls on various topics that we've thrown at you. So thank you so much. And Laura, thank you for facilitating today. As I mentioned at the top of the meeting, we're here as the ACSA HR Council to support you and bring you timely information. So before you head out today, if there's topics you'd like to hear in the future, please put them in the chat box and we'll coordinate other sessions like this. Or you're also welcome to email me at hwilliams@rcoe.us, and we'll look forward to continuing to serve you throughout the year. So other than that, you're welcome to put ideas in the chat box. Otherwise, have a great Tuesday. Bye, everybody.